Deadly conduct. What does that even mean? How do you defend a deadly conduct charge? I'm Jeff Hampton with the Fulgham Law Firm. Thanks for joining us here today on our YouTube channel. And today I want to go over the ins and outs of Texas law related to the charges of deadly conduct. What does it mean? How do you know? Is it a felony? Is it a misdemeanor? Is there a way to defend it? What type of facts fit that crime? By the way, if you wait around to the end of this video, I will also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, let's jump right into this. Now listen, every single one of us has lost our temper at one time or another. And as you know, fortunately, most of the time when that takes place, things are resolved civilly. But as you've seen in the news, there's been a lot of news stories over the last few years about road rage incidents that when they do not resolve civilly, what ends up happening is there ends up being assault charges, aggravated assault charges, or deadly conduct charges that can arise from that. So, and by the way, also, because not all assault charges have to be just some sort of barroom brawl, right? But I want you to also understand, you may be one who has a concealed handgun license. Maybe you carry a weapon with you all the time. Well, be aware of this. You do have a right to exercise your right to bear arms regularly, and you can do that here in the state of Texas. But I want to warn you, you also face an increased risk of being charged with deadly conduct if tempers flare and a weapon ends up being used in any part of that process. So let's jump into this. Under Texas Penal Code section 22.05, it defines deadly conduct as a crime committed when one person, quote, recklessly engages in conduct that places another person in imminent danger of serious bodily injury. Now, it's an umbrella term for really that kind of comprises several types of assaults and heavily focuses on the potential harm as opposed to actual harm, okay? That's what it gets here. So deadly conduct usually accompanies what a police officer believes is reckless behavior. Remember, there's different types of intent under criminal law. There's intentional, there's knowing, there's reckless, and there's negligent, okay? We're not talking about something intentional or knowingly. Here, the officer's claiming that what was done was reckless. So sometimes you'll find some overlap between aggravated assault charges and deadly conduct charges, especially at the lower levels. But deadly conduct is usually charged in cases of recklessness as to situations where the police can show that someone really was intending to hurt someone. So, Texas law says this: recklessness and danger are presumed if the actor knowingly pointed a firearm at or in the direction of another, whether or not the actor believed the firearm to be loaded. Now, that's a big deal, okay? So it's really important. Bearing arms in this, you have the right to bear arms, but be careful. It comes with a pretty stern warning label, and it comes with the responsibility of making sure if the gun's pointed, doesn't matter if it's loaded or not, you could end up facing a criminal charge. So firearms should be handled carefully at all times. And of course, we know if you've ever taken a gun safety course, which many people that have gotten a concealed handgun license have done this, we know that's a basic tenet of every gun safety course on the market. But essentially, you should always act and presume that the person on the other end is always thinking that the gun that you have in your hand is loaded, even if you are sure that it isn't loaded, okay? The law doesn't make that distinction. Otherwise, a mistake could land you a deadly conduct charge. So I'm going to identify very quickly 4 specific ways you could potentially receive a deadly conduct charge in the state of Texas. The first way you can get a deadly conduct charge is by taking some type of action that puts someone else in immediate danger of receiving serious bodily injury. This is kind of the textbook definition of reckless behavior. So reckless behavior, of course, is one of the lowest level deadly conduct charges that exist under Texas law, and it carries the lightest sentence. A Class A misdemeanor of deadly conduct would be punishable by up to 1 year in county jail and up to a $4,000 fine. So Maybe an intense road rage situation or unsafe or reckless driving practices might be considered deadly conduct by law enforcement. You'll see that happen on occasion. But that's the only one of the deadly conduct categories that is a misdemeanor. We're now going to talk about the next three that are all felonies. In fact, they're all third-degree felonies under Texas law. So the three I'm about to go over with you, all are third-degree felonies punishable by up to 10 years in prison and up to a $10,000 fine. Now, the first one is firing your gun. So firing a gun at a vehicle or a vehicle or a building is empty, well, that's one thing, okay? But practicing shooting at I see people they go out and practice shooting at an unoccupied barn or old cars or something like that. Okay, that's pretty common. But just assuming the structure is empty, that's a problem, okay? Don't ever assume that a structure is empty or a vehicle is always empty unless you've really made inspection of it, and you better make sure it's abandoned, okay? So my point is, you have got to do your due diligence and knowing for certain that you are not firing at an occupied space. Otherwise, by doing that, firing your weapon, that could lead to deadly conduct charges in that situation because it could be considered legally reckless. Okay, number two. So number one is firing your weapon at a building or at a structure or a car of some sort. Number two is pointing a firearm at a person. Now, look, if you know anything about Texas law, you grew up understanding guns should never be treated as a joke. Obviously, they can land you in trouble if you're not careful. They should never be pointed. I'm going to tell you, the police are trained on this. I've had instances where it shows that my client didn't do anything wrong, but when he pulled out a gun, that client pulled out a gun and pointed it at someone, my client ended up being the one that was arrested because he pointed the gun at the individual. So pointing a gun at another person upon whom you do not intend to fire, you can say all those things you want, but be aware the police have a tendency to be on the side of the party that didn't have the weapon. That's just the way they tend to look at it. So I just want to warn you about that in advance. So according to the law, even if you sincerely believed your firearm was empty and you had no intention to ever fire, pointing a gun at another person, the police are always going to think that's a felony deadly conduct action on your part. Now, finally, we're going to get to now, the next point is firing at an individual. This is kind of obvious, right? But think about this. It's perhaps the simplest and most clear-cut example of deadly conduct behavior. And of course, there's a very fine line between this and aggravated assault with a deadly weapon. And I've seen them kind of go both ways in this situation. If you recklessly fire a weapon at or in the general direction of another person, it is illegal and it is considered a third-degree felony. And firing, now I'm going to get into this, but one of the defenses to this is is something that is either mistake or accident, okay? Now, I actually represented a client one time that was cleaning his gun in his apartment. He was on the top floor. And he was cleaning his gun, and in the process of cleaning it, the gun went off. And it went through the wall into the bottom floor and narrowly missed a lady in there fixing her hair in her bathroom. Well, I mean, can you imagine what happened? The police show up. This lady freaks out. She's traumatized by the whole thing. My client's like, hey, I wasn't trying to do this. The police said, yeah, buddy, okay, maybe you weren't trying to, but we think what you did was reckless. You shouldn't be cleaning your gun in your apartment like this. He was arrested for exactly this charge of deadly conduct. We were able to resolve that case for him in a way where it was dismissed, but it was very important that he understood in that situation, the police see a gun, it's being fired, guarantee you somebody's going to jail. There's going to be some sort of consequences. So if you fire by accident or without checking whether it was clear before firing, those are two scenarios in which you could be charged. And so, as you know, there's always exceptions to the rules on these things. But one of the things I want you to understand is when you examine something like this, it's clear that having a weapon is a wonderful thing that you can have under your constitutional rights. And that's a great thing. But be aware if you get into a situation with someone else and a weapon is used or it's exhibited or whether it's shot, whether you don't shoot it or not, but the other person says they're in fear, you could be facing a deadly conduct charge in the state of Texas. Now, maybe you or a loved one is going through a deadly conduct situation like this, and you would like a free case analysis, a free case consultation. we'll be happy to do that, especially if your case is out of the North Texas area. Don't hesitate to contact the Fulgham Law Firm at 817-877-3030. Be happy to go over that with you. And by the way, I promised you waited around to the end of this video. Click on the link below in the video description, and we'll be happy to send you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. I hope this was helpful. If you liked the video, subscribe to our channel. We'll send you more great content like this. Look forward to seeing you on our next video series, and we'll go over our next content. We usually present once or twice, at least a month, and I look forward to sending you more content just like this. Take care.